May I please? These are item number 4 and 5. It, what will be, this is your appropriate bench, but.
Oh, yes.
The registry should have done it.
I have talked with Amicus Curie, Mr. Mohan Kumar. He said next Tuesday or Thursday it will be over.
Okay.
It has to be constituted, I think, the bench.
Special bench it will be. Just a moment. Then make it 14th.
Yes.
Just after Diwali.
14/11.
This matter before the appropriate bench. On 14/11/2023. Item 4, 5. These two matters.
Back to list on criminal appeal 275/23.
Yes, nobody is stopping you to list it. You said you want to list to it, but if you want me to list, then give it to the court master. Correct?
Daily list item 1, division bench.
That's Then counsel for the appellant is present. Seen the office note dated 7/11/2023, indicating that notice issued on the respondent by usual process was not received by the respondent. Moreover, notice issued by registered post with AD was also returned unserved with postal remark refused. So accordingly, notice on respondent 2 is deemed to be duly served. As the matter is otherwise ready for hearing, list the matter for hearing. You're not giving a date.
Item 2 with 3.
Yes.
Before starting the submission, making the submission by my learned brother, in support of this case, may I propose one thing, your lordship? That the letter can be sent for mediation.
Our party is ready for mediation. Have you
My
spoken
party
to-
is ready.
Yes, Dr. Deka.
Probably, my party will also be ready for that, but,
You can just go out, speak to them and come back after some time. Because unless you see, we have seen that it is best on part of both sides to have it settled on mediation.
Yes.
But the other factor is that if the parties do not consent,
Right.
then there's a larger possibility of failure that we want to avoid.
Lordship,
So if required, we can keep it on any other day when you want, so that the parties can be heard and sent to mediation. Or if you can speak to the party and then report that they are ready. So we'll take it after some time. Just try to contact them.
can the party, the personal appearance is,
No, personal pay is not required because you know the parties well.
yes, yes, yes.
Correct. The intention of us to call the parties is only to assist them to come to a decision, to go for mediation. But if you can convince them, there is no point calling them. So you come after some time,
5 minutes.
or 5-10 minutes, whatever. Before I think you can come and tell us.
Okay.
Also-
Supply item 8.
In fact, yesterday, as I was saying, there were few High Court judgments where this aspect has been dealt with. And I have seen, Lordship can see once both the judgment. I've mailed it, and it's also in the Supreme Court. It's a High Court of the two High Courts where one was of Allahabad, where it is said that although the POXO, the consent will not matter and all because she is minor, but then still with time law has to change. And so here what had happened, young boys, because of romantic relationship they get into, and then something happens and they are inside the bars. So some kind of a difference is culled out in those judgments. Yesterday I have sent two mails. This is one is Atul Mishra versus state of UP, and another, it is Allahabad High Court. Atul Mishra versus, yes, Lordship can, I have sent it from Supreme today, Lordship can also find. There, Atul Mishra, their 389 application was heard and bail was granted. Lordship will go to paragraph 12. Here, of course, both the boy and the girl were minor. In our case, boy is not a minor, but the second case is of that nature. The boy was the major. Here, Lordship will see paragraph 12. There can be no second thought as to the seriousness of offense under POXO Act and the object to achieve. Enactment of POXO Act was to effectively address the heinous crime of sexual abuse and sexual exploitation of children. The act was introduced to provide protection of children from offenses of sexual act and harassment. The act also provides for safeguarding the interests of the child at every stage. But this laudable object must have some genuine and inherent exceptions too. It is imperative for the court of law to draw that line that demarcates the nature of acts and should not be made to fall within the scope of this enactment. There are certain gray areas where the severity of the sentences provided under the act, rightly so, be diluted, keeping in view the facts of each case. If these rigors of the enactment is pasted hastily or irresponsibly, it could lead to irreparable damage to the reputation and future of young, whose actions would have been only innocuous and may lead to spoiling the future life of that innocent lovers or couples who out of sheer innocence have initially developed and thereafter established that relationship which, if seen through the biscope of these provisions of 2012, would fall within the realm of offense. Now, so many discussions were made, growing incidents where teenagers and young adults fall victim to the offenses
No, but
of
here you see, this was a consideration while taking a bail matter.
bail matter.
Here, a boy was arrested in 21, and in 22, the court is granting them bail after 1 year
Yes.
of incarceration. 389 circumstances are, we'll have to evaluate something more.
This is also 389.
No.
They were convicted.
No,
Acha.
it's criminal bail matter.
But Lordship will see first,
They are facing prosecution. He is
Acha.
facing prosecution.
They are facing prosecution in grave. Lordship can go to the second case. There it is, they are in fact acquitted. This is Ashik Ram. This is Ashik Ramzan Ansari versus State of Maharashtra. Here they were convicted and then appeal was filed and they were acquitted. And here the boy is not minor. Lordship will say this, Ashik Ramzan Ansari. The first paragraph shows that, in Greater Bombay for the offences punishable under so-and-so, Protection Act, and stands convicted by judgment, he is undergoing sentence of so-and-so. And here the boy was also not minor. This is which court? This is Bombay High Court. For single bench. There he was in fact acquitted on these grounds.
Again, same thing. You see, acquittal and enlargement of bail.
This is again different. Acquittal, Lordship will see everything. So these two judgments I got where a distinction is made from the normal procedure. Like consent also it was dealt with. Initially it was 16 years and then it was made to 18 years. Although consent will not matter if she is minor, but then the differences were made. Here the boy they were in a relationship and then they got a call from one girl that the boy is married and after that the FIR was lodged. But then this was, and the boy was acquitted. Of course, not for 389.
This was a conviction into which section?
This POCSO.
No, 6 or 4?
Clause,
4.
4. 10 years, I think. Oh, in our case.
In our case,
Oh, in our case, yes, 20 years, 4.
section 4.
that in this judgment, it is also said that criminalization of these romantic relationship has overburdened the courts.
Simply also overburdened.
What we are proposing is that, as we are aware that the translation section right now is busy in the under the directions of Supreme Court doing some translation works. So every likelihood for this month they will be preoccupied. In view of the nature of evidence which is available in this case, especially the conduct of the girl, we are proposing that next week, say on Wednesday, we hear the matter and take up the matter on merit and disposal.
On the basis of
So
the records.
these records are here. We'll give you the records to peruse it.
Paper book will not be necessary.
Paper we will dispense with. You have the copy of evidence? You have copy of evidence. You make a photocopy and give one to the London APB to give it to Ms. Jan. Make a photocopy today and give it to her. So we take up the matter and hear it on merit.
Then this Ramzan Ali judgment will help. Because it's single bench, logic can only refer.
That's okay, then we can take a call, whatever way it be. We can't say what you will take. But we'll make an endeavor to hear it. But Mr. R. Chetri, as well as Ms. S. Jahan Laner APP for the state,
Is for the.
as well as Mr. S. J. Sharma, Learned Counsel for the respondent number 2 and 3. It appears that the effort which will take to dispose of the this interlocutory application, with the same effort, the appeal itself can be heard and disposed of. So accordingly, next para, we understand that the translation section of the registry is in some urgent matters. So accordingly, we dispense with the preparation of the paper book. So the learned counsel of the petitioner submits that he has the evidence of the witnesses. So therefore, a copy thereof is served on the learned APP as well as to the learned counsel for respondent number 2 and 3. This is the matter for hearing. This is the connected appeal for hearing on 15/11/2023.
Item number 2. My party has agreed for it.
Okay, so you suggest a date?
28th of this month.
28th of this month. What do you think? Dr. N. Dekar, and counsel for the petition appellant, as well as Mr. R. Bhuiya, learned counsel for the R.K. Bhuiya, learned counsel for the respondent. Next one. The learned counsel for both the parties, with the consent of the respective parties, have agreed to make an endeavor to settle the dispute between the parties in mediation. Full stop. They have both suggested the date of 28/11/2023 for mediation. Full stop. Accordingly, and if this is next para, accordingly, let an effort be made for amicable settlement of the dispute between the parties through mediation. First off, let a copy of this the counsel for the parties shall send a downloaded copy of this order to the applicant and the respondent, which would constitute notice of participating in the mediation process. Next paragraph, that the copy of the order be sent to the Guwahati High Court Mediation Center so as to enable the mediation center to facilitate settlement of matrimonial dispute between the parties through a learned trained mediator on 28/11/2023. Most of the parties shall appear at 11 o'clock on the said date. Next part, the mediator would have would make an endeavor to settle the matter within 16/12/2023, and the come up with liberty to seek extension of time if so warranted. List on 20/12/2023 along with the report of mediation. Yes. Okay.
Item 6 for hearing.
Lordship, my senior is on legs in another court. The matter may be after some time possible.
We can't wait because this bench would have done no other work. We can't.
After matter 7. It can take him after matter number 7.
Okay. Okay, item 7. Right.
For listing of 3 motions tomorrow, Lordship. Because urgency is there. All the 3 petitioners that are student of IIT, they were expelled from the university. Earlier, and they file appeal. It is to be decided, and their examination was scheduled to be 15th. But yesterday there has been preponed to 11th.
Okay.
Thank you.
Lord, I'm mentioning item number 4 and 5 regarding election and appointment of principal. 7 years, my lord, very old case, my lord. It's revolving around only one aspect, the meaning of research guidance under the CE. It only come on next Thursday, my lord.
No, not Thursday. Thursday because I have 2 division bench. I have a single bench. Let the court master decide. Distance so and so. He'll take a call and decide because Tuesdays and Thursdays are almost in these few weeks.
Next,
He'll take a call. Item 4 and 5.
I'm praying
Due to
for
positive time matter could not be taken up today. List on so and so. Just let him check and decide. Prayer for listing, give it to the court master. I am not saying what the date. Let them fix the date.
with regard to item number 10. 10.
10. Oh, that ACB matter.
Yes.
Yes. Again, today we won't be able to take up.
14th or 21st.
14. Possibly the matter could not be taken up till this one 14. Item 10. But 14th also, because all matters before vacation are being deferred. You can try giving a written synopsis. Because, huh?
It's on part of the report.
Is a part of the record. Okay. Even if you have something to say, please make it written, because since it has been kept parted for quite a long time point of time, I otherwise I'll have to release that from parted. Three. No, in 3 you are for item 3. No, there's something here. Item 3. Why are you seeking an adjournment? But we should have done it. This is a 2016 matter and you are delaying the matter. That's why I had flagged this. The 2016 matter fixed for admission. Because if you want to have a delay, then we issue a rule and list it for hearing. Don't do it. It's a 2016 matter. You have your delays at your end. Oh, okay. List after 2 weeks has paid for by and counsel for the petitioner. Both sides are represented.
Madam, I am for item 10, madam. I apologize, madam. I forgot. Madam, Mr. Kian Goswami is indisposed. Mr. Kian Goswami is indisposed. On the other day, your lordship was pleased to fix a matter on 29th.
Item?
Item 10, my lord, you had just mentioned.
Uh-huh.
Mr. Kian Goswami is indisposed, my lord. My lord had previously fixed a similar item on 29th. May I pray that this matter be fixed on 30th, subject to lordship's convenience? By the time.
30 is not a. Maybe not the internet. 30 November. That item 10.
10.
Okay.
30 here. 28th, my lord. 28. 28.
2-8. Okay. 2-8.
I'm obliged.
Yes, item 1.
Maybe
This matter may be adjourned. The response will be suffering.
otherwise lordship has rejected it once. That is how it has gone.
No, just one.
By injecting some, by making them have some intoxicants, he looted the articles. The co-accused is inside, but the accused is praying for anticipation.
The case diary be required.
Lordship has produced a case diary and a passed the order that several He uses several names and all that. He is also wanted in some other case. Up to date case diary, if the lordship wants to say,
Get the updated case diary,
not.
get the updated case diary. We produced updated case diary uh, and a report of previous criminal antecedents of the petitioner. We produced on when
Not any date, today is 9th, so 20th or next week, 16th? Any day,
16/11.
16/11. Lordship.
Oh, no, not 16. We'll make it 17.
17th, Lordship.
Okay.
Item
Item 2. Just a moment. We should notice in this matter. Unless I look at my past reading, I'm able to make up my mind. Mr. S. Bhattakur, counsel for the petitioner, and Mr. B. Kaushik, learned standing counsel for the school education department, secondary education department, appearing for
Respondent
One.
3 minutes.
4 also.
Oh, sorry, 4, 3 minutes.
No, I think you'll have to make correction. He is not, now he's district commissioner instead of deputy commissioner.
That is district commissioner.
Now he's district commissioner. Okay.
Now it's-
1, 2, and 4.
4.
This principal you are not appearing.
It's full line.
And Mr. P. Saikya, government advocate appearing for respondent number 3. Everybody non-provincialization of service of the petitioner. The present petition has been filed under Article 226 of the Constitution of India. The issue notice returnable in 4 weeks. Requisite extra copies of the petition be served on the London State and Departmental Council in the course of the day. Next, brother. The petitioner shall serve notice in the respondent number 5 by registered post with AD. You can serve by Dasti also. Full stop. In addition, notice shall also be served by way of Dasti by routing the process to the registry of the court, and upon service, every service will be filed. And there's this listing. That's all I think. Okay.
List of the-
to item 6, sir. 6.
Item 6. Yes, you have got instructions.
I was supposed to file the affidavit in opposition, but due to puja vacations and the office of the management school management is from Kolkata. so we could not make out.
They are not believable. Not ground is not very convincing. These are
If permitted, I can file on the date. If permitted, I can file.
by when?
After 2-3 weeks.
No, 2-3 weeks is too long. You see, what you call appointment is discontinued. This is a repetition of 2020. Correct.
Major part was during the lockdown. Major part went during the lockdown. So, matter is,
No, you see, it doesn't impress us. When somebody is not out of employment, Because I've tried, by virtue of my religious belief, not by religion, with my religious belief, at times I do fasting. Right? And I know it is difficult. Have you tried fasting?
Yes,
How many days?
very rarely. Very rarely.
Very rarely. So therefore, once one is out of employment, you must think that how difficult it would be for putting a lock on the stomach. Correct. Do it within 10 days, filling which cost of 1 lakh rupees. Correct. Otherwise, pay her 1 lakh rupees. It's not very much, very difficult. It's a tea garden.
Tea garden.
So 1 lakh rupees is nothing. Puja bonus. Both sides represented.
On 10/4/23, 4 weeks to file affidavit, if not, ex parte order will be passed. That is the order. of
We are giving you
10.
1 lakh rupees. What more do you want? You want more than that for the time being. No.
If Lordship, if I don't file in another 10 days,
Then 1 lakh. Mr.
Yes, sir.
S. Sharma, Learned Counsel, for the respondent number 6 and 8. Praise for adjournment. To file affidavit in opposition in the matter. It is seen that notice of motion was issued by order dated 5/2/2020. So, however, although the petitioner is no longer, or the petitioner's service has been discontinued, and therefore, while granting time to the respondent number 6 and 8 to file affidavit in opposition, it is the court is inclined to provide that on failure of the respondent number 6 and 8 to file affidavit in opposition within 10 days, the said respondents would jointly and severally be prepared to pay a adjournment cost of rupees 1 lakh. Next paragraph. Affidavit in opposition shall positively be filed. Count 10 days and give it next date. 10 days will be, today is 9th.
Working days may be counted, Lordship. There is
No.
Diwali vacation.
You work Saturday, Sunday overtime. Correct. If not, you come and stay with me for Saturday and Sunday and look at me working. Correct. I have not seen a Saturday or Sunday. Except when my family members catch me by the neck and then pull me out of the home. Except for those days, I have not seen a Saturday and Sunday. So don't say about that. 10 days today, 9th is 19th. 2011-2023. This on 22/11/2023. I'll have to raise, there's a reference for Honorable Chief Justice. You wanted to say something?